Okay, I'm going to go ahead and call this next case. It's People versus Boykin. This is a 15-minute mini oral argument on the application. Mr. Karfonta, you may proceed, and you can turn your screen over to Ms. Ward whenever you would like to. Go ahead.
Thank you. I'm not exactly sure about the turnover, but let's just get to the end and we'll go. So the cornerstone, good morning. The cornerstone of the social science underlying Miller is that the character of children is that they are less culpable than adults. And the cases in the social science set out three basic factors which fit right into this case. One, children are subject to vulnerable to negative influences. They have little control over their own environment and have almost no ability to extricate themselves from even horrific situations. Here, Demariol Boykin lived in Chicago with his mother. They moved him to Grand Rapids with his father. And on the day of the incident, the father packed up the three boys in the car to go looking for the victim to assault the victim. Demariol Boykin had no opportunity to not participate in this family outing. The second social science factor is that youth are reckless and impulsive. And to the pre-sentence investigator, Demariol Boykin said this: everything was happening so fast. I was so mad. The third science factor is that the character of youth is transient and it is not fixed, and that it is uncommon for youth to have irretrievable corruption. Here, Demariol Boykin had no prior assaults and has had no subsequent assaults. The resentencing judge treated this case like an adult self-defense case, saying this, quote, "This was an intentional act. It wasn't provocation over a short period of time." And about age, he says this, quote, "Defendant was certainly of a mature age, and he cannot blame youth or immaturity, agreeing that a 16-year-old is a grown man," close quote.
Mr. Karfonta, let me get to some questions, just because you have such time is so short, and I want to make sure you're able to answer any questions that the court has. So I'm going to start with Justice Bernstein.
Counsel, good morning, and I appreciate your arguments and thank you for coming. As it pertains to the fact pattern of this specific case, is this really the best vehicle?
Is what the best vehicle?
Looking at the facts of this specific, based on your argument, is this specific fact pattern the best vehicle in terms of what happened here?
I'm just not understanding you, Judge.
Okay.
I'm sorry.
I guess the question I'm posing to you is I've listened to your arguments. I understand your arguments. I understand, the arguments that you're making, but I mean, this seemed to be a little bit more than a family outing. I mean, participating in a family outing, it seemed like this was a pretty vicious circumstance and crime. I guess what I'm trying to ask you is that does the fact pattern of this specific case create more challenges as it pertains to the issue at hand?
I understand. Thank you. I would reply with this. Roper v. Simmons, which is cited in all the briefs and quoted in all the briefs, talks about not allowing these horrific facts to set aside the characteristics of youth. And it's like I say, Roper is cited in all the briefs, including mine. And I think that, so my answer is yes. And further, to sort of jump ahead on my argument a little bit, this judge relied on the horrific facts. he contradicted the science throughout. He was not silent on the science. And so regardless of this court's rulings on the Wines-Miller issues, this resentencing was based on inaccurate facts as opposed to established science. And resentencing is going to be required in any event. And that's my position.
Thank you, counsel.
Justice Clement.
Go ahead.
Thank you. So just following up on your response there. So if we agree that Wines was correctly decided, what is it that you think should be articulated by the trial court, and not necessarily in this case, but generally to support the sentence that is imposed on resentencing?
I think the trial court should articulate their response to the three factors that I just set out. The benefit of the articulation is, one, because the statute has no sentencing guidelines, two, for review, but in my mind, more importantly, to avoid the kind of record here where there's rash and arbitrary statements being made by the judge, to get the judge and the lawyers to focus in on the characteristics of youth issues that are the feature of these cases.
Okay, thank you.
Justice Cavanagh.
I guess mine is similar to Justice Clement. If we were to agree that, you know, the attributes of youth should be considered by the trial court at sentencing, because that's consistent with Snow and the factors that should be guiding the trial court, and those factors should be considered mitigating factors. What evidence in this particular record at the sentencing would support your contention that the trial court, I mean, there's no question that the trial court was aware of Miller, and you know, there's been talked about it on the record. He disagreed with it, obviously, and had opinions about it. So he considered it, but is there evidence that that the trial court didn't consider the Miller factors as mitigating evidence? And what would that be? Mitigating factors, I should say.
Yes, I think that, and I could quote many things from the transcript, but I will just go back to the quote that I had read to the court. I think this clearly contradicts the idea of a transient character in youth. Defendant was certainly of a mature age, and he cannot blame youth or immaturity. A 16-year-old man is a grown man. That definitely contradicts the accepted in science and accepted in cases, the accepted science in this case. And he goes on in this fashion, and all those comments, the record is not silent on Miller. Rather, he's not merely rejecting Miller and saying, I don't agree with that. He's relying on factors that contradict the science, making this an inaccurate sentence.
Okay.
A sentence based on inaccurate facts.
Okay, thank you.
Justice Welch.
And no questions at this time.
Justice Zahra.
Doesn't the prosecution's decision not to request a life without parole sentence necessarily mean that defendant is obtaining a meaningful opportunity for release and essentially receiving the benefit of the Miller holding? In other words, isn't Miller already accounted for in terms of your sentences?
No, because the record doesn't demonstrate that, in my view. The record demonstrates a contradiction of the Miller factors. The prosecution made that decision, but in this case, and it's also discussed in the briefs, in this case, it's really meaningless. This defendant is now over 30. He would be over 60 before he's ready for release. A time in prison is not like time in Leelanau County.
Okay, thank you.
Justice Viviano.
No questions.
Counsel, I have one question. Is it your view that what would you, if you could write the rule here, what would you have trial courts do exactly? What do you think trial courts should be doing in a case like this? Go ahead.
I don't have a proposed rule, but what I would say is that the trial court should consider the three factors that I mentioned: the lack of control over environment, the impulsivity, and the transition. Consider those factors and account for them on the record.
Okay. Counsel, should we turn it over to Ms. Ward for some?
Yes,
okay, absolutely.
That would be great.
Yeah.
Thank you.
Yeah, no problem. Ms. Ward, I'm going to just let anybody interrupt you if they have a question, and otherwise let you control your time.
Good morning. May it please the court. Claire Ward on behalf of Amici State Appellate Defender Office and the Criminal Defense Attorneys of Michigan. The Supreme Court in Roper, Miller, Graham, Montgomery, all the way up until Jones, they've stated quite clearly that youth matters in sentencing. And Michigan jurisprudence is clear that sentences that are not subject to the sentencing guidelines, such as sentences under MCL 769.25, must be proportionate to the offense and to the offender, and that trial courts must balance the SNO sentencing objectives of reformation of the offender, protection of society, punishment, and deterrence when crafting an individualized sentence. Now, this court should issue an opinion stating that the trial courts must consider youth and its attendant circumstances when they are relevant to the offense and the offender, as in every term of year sentencing under MCL 769.25, because those characteristics are necessarily baked into the SNO sentencing factors. And this court must direct trial courts to articulate their reasons when crafting a sentence under MCL 769.25 in order to facilitate appellate review. But finally, this court must clearly... Yes.
Ms. Ward, can I ask, what is the support that you have for that last point you made of articulating the requirement that it be articulated on the record? Where is that coming from? The statute, from our case law, from the Constitution? Where does that come from, the articulation requirement?
Yes, Your Honor. The articulation requirement is from Coles, and Coles was quite clear that articulation of reasons at sentencing facilitates appellate review and is therefore necessary. And here, where there are no sentencing guidelines, we don't have a grid at which to look at and say, oh, the court considered X, Y, and Z in crafting this sentence.
So it's almost the lack of guidelines require the court to articulate because we don't have guidelines in which to consider the reasonableness of the sentence?
It's the lack of guidelines, but it's also the fact that these cases are some of the most serious in Michigan. And in order for the public to be assured that justice is being dispensed in a fair and equitable manner for all people who are to be sentenced under this statute, we need to know what the trial court is considering in each individual case. And
so is this sort of an exception because of the seriousness and the fact that they're youth? Is that sort of a justification of an exception to the sort of general rule that trial courts aren't necessarily required to articulate on the record the basis for the sentence?
I don't think it's an exception, Your Honor. I think it's simply Coles reasoning that in order to ensure fair and equitable distribution of justice, we must have articulation of reasons. And when there are sentencing guidelines, we understand what those guidelines are and we can look at those. But here, there are no guidelines. We must have articulation.
Okay, thank you.
Ms. Ward, I'm going to jump in and just sort of piggyback on what Justice Cavanagh was asking. So I understand what you're saying regarding this specific instance with sort of the lack of guidance with the range. If we were to agree with your position, will this impact other youthful offenders or just those who commit first-degree murder?
So in this case, I think that the court can find that youth and its attendant circumstances must be a part of proportionality analysis under Milborn and the SNO sentencing objectives, and therefore limit it to Michigan jurisprudence. However, I do think that the Michigan Constitution cruel or unusual punishment clause and the Eighth Amendment would support this in other cases, but those cases are not currently before this court in Boykin and Tate.
Thank you.
Counsel, do you want to reserve 36 seconds?
No, I'm
Yes,
gonna take it up.
Too bad.
Sorry.
Too late.
Just help me understand, what legal basis is there to support applying Miller to sentences in a term of year case? Miller itself is limited to mandatory life without parole sentences. And the statutes passed by our legislature do not require consideration of Miller's distinctive attributes of youth when life without parole is not on the table. So how do we get there?
Your Honor, I believe it's because youth has always been considered in a traditional proportionality analysis under Milborn. For at least 50 years, courts have been concerned with the youth or lack of youth of an individual before the court. Back in Lorenzen in 1972, the court was concerned that a mandatory sentence would disproportionately affect a high school student who was being sentenced under that mandatory statute. So this court can find Michigan jurisprudence going back at least 50 years, which considers youth to be an important aspect of consideration when sentencing children. And I think that this court doesn't have to skip ahead. Miller made it clear in the life without parole circumstance, but now here we are with term of years defendants under MCL 769.25. And I find that right under Michigan jurisprudence as well as the attendant constitutional provisions.
Thank you.
Any additional questions for Ms. Ward? Okay, thank you, counsel. Mr. Benison.
Good morning. May it please the court. James Benison with the Kent County Prosecutor's Office on behalf of the people of the state of Michigan. In Miller, the Supreme Court mandated a process under the Constitution to separate those juveniles convicted of first-degree murder who merit life without parole from those who deserve a chance at release. Justice has mandated a process be followed in death penalty states when that ultimate penalty is sought. But the Michigan legislature permits prosecutors to make the determination that a particular juvenile convicted of first-degree murder does not merit life in prison, just as states with the death penalty provide discretion to prosecutors to forego that highest penalty in a given case. But once that decision is made, the purpose of the extra procedural protections has been fulfilled. They are no longer constitutionally mandated, and a normal sentencing takes place. As Justice Zahra mentioned, and as we mentioned in our brief, the legislature also required the extra processes for when life without parole was sought, but not for term of year sentences in 769.25. As I read the defense and the amicus arguments, they are arguing that essentially a Miller hearing should be held in every non-life without parole sentencing case because sentencing courts lack guidance in how to exercise their discretion. But trial courts are required to impose a reasonable sentence guided by the principle of proportionality to be reviewed by the error-correcting Court of Appeals under an abuse of discretion standard. We already have in place a requirement for articulation of why they chose their sentence to determine if it's a valid sentence or an abuse of discretion. We don't need to add on additional levels, and I don't think that there's authority to require all the extra steps that the defense is suggesting here. To me, the defense is arguing that the heightened standard of review espoused by the Court of Appeals in Hyatt should be imposed here because we can't trust the trial courts. But this court in Skinner said, no, it's a traditional abuse of discretion standard in life without parole cases, and there's no basis under the law to add a heightened standard of review in a non-life without parole sentence. We've been advocating for Justice Clement's interpretation in Wines all along that the case should simply stand for the proposition that age and a person's background matter in sentencing. If that's all it is, that's fine. We want that clarified because there are defense lawyers and judges who are interpreting it to require far more than that. We've never argued that a person's age is irrelevant. It's simply that the process required by the Constitution and the statute in one area can't be expanded into other areas. Nothing more is required under the separation of powers. We submit nothing more is permitted.
Counsel, can I interrupt you and see what questions folks have? Yep.
Absolutely.
Justice Bernstein.
Hi, counsel. Good morning, and thank you for joining us today. I think you've pretty much answered it, but I just want to make sure. What latitude does this court really have as it pertains to the decisions that we're going to make on these cases?
I don't think this court has the authority to impose a new mandate in non-life without parole sentences to have all of the Miller factors done in a matter with experts and all the other things that go with it. That would be an unfunded mandate. And it would also actually create an incentive for prosecutors to simply seek life without parole in every case, which is not what we want them to do. We want them to make the analysis beforehand. And if it's a clear case, to not go through this whole process. I think that your authority is simply to say, trial courts do what you've always done, which is we trust you to look at the facts and come up with a proportionate sentence, and then we'll have the Court of Appeals review it for an abuse of discretion. I think that's all that you have the authority to do, and that's all you need to do.
Counsel, thank you.
Justice Clement?
Thank you. Two questions. First, these cases, the ones that fall in where there's a mandatory minimum of 25 to 40 with no guidelines attached, that seems very unique to me when I look at our sentencing structure. It seems like the only, from what I've been able to see, the only time that you see that where there's not guidelines that help guide the judge. And so with that in mind, is there something more that should be expected or required here to ensure that when sentencing occurs and is up on appellate review, that there is adequate, there's an adequate record for the court to review?
I don't know that anything more needs to be ordered, because the court already has in place rules for trial courts to follow to say, hey, you need to come up with a reasonable sentence that is proportionate, which looks at the circumstances of the offense and the offender. They need to talk about those things. They need to provide enough information for appellate review of it. The issue here, as we see it, is whether there is a checklist of extra things that need to be provided and whether that requires additional processes and procedures in the sentencing hearing. I would agree. I don't know of any other circumstance where there is this kind of a range given to the judge without guidelines, but it's partly because the court can't go outside of those guidelines. The guidelines have been said to make a sentence presumptively proportionate if they're within it, but you obviously can't go outside of 40 years or under 25 because that's what the legislature has said. So the presumptive proportionality is a little misapplied here. It's a range within 15 years. And as I mentioned in my brief, there are lots of sentences possible for a trial court to do with a far greater range. And we say, if it's within that range, okay, you've done your job. I think here it's simply a matter of talk about all the things that normally come into play in a SNO sentencing.
Okay, thank you. And then my second question is, thinking of this case in particular, I'm sure that you're going to argue that what the judge put on the record is enough to satisfy. We've got a couple of statements that are made that indicate, that a statement about a 16-year-old being a grown person and age not coming into consideration, or the youth not being an issue. Is something like that something that, upon review, we're trying to give some guidance, right, to trial courts. Our comments like that, if we take those out and a judge simply looks at everything and says, I took youth into consideration in this instance, I don't think that there were mitigating factors based on the defendant's youth. And here are the reasons that I'm going with, let's say, 40 years. Let's say that they're going with the minimum of 40 instead of the low range of 25. Is that enough, or does more need to be discussed during sentencing to kind of to pass the bar as to what's required to discuss some of the Miller factors?
Each case is going to be somewhat factually dependent. For instance, one of the Miller factors is, to the extent others were involved in the case and whether peer pressure was involved. In this case, because family members were involved, that's part of why my office chose not to seek life without parole. But certainly there are some murders which occur where the defendant operates completely solo. And we don't really need to talk about the influence of peer pressure in those cases. So to say that the courts need to discuss each of the Miller factors specifically in a given case invites roteness without actually spending brain power. The issue for a proportionate sentence is, okay, here we're looking at this defendant and he's 3 months shy of turning 18. The defense takes a lot of umbrage at the use of that categorization by the trial judge. But as I mentioned in my brief, the argument is with Justice Kagan, because in footnote 8 of Miller, she said, hey, look at whether it's 14 or 17 and a half. Look at the nature of the offense. Is it aider and abetter or a horrific crime that's far more personally responsible? So it's entirely permissible for the court to say, given his facts and circumstances of this defendant, that because of his being the only one to bring the gun to the fist fight, him being the only one who said to his own brother, I shot him because of a prior involvement with him, discounting his subsequent claims, the fact that he had the psychological assessment that said he's likely to be defiant, and 13 years later, he's still having weapons in his cell 6 months before his resentencing. All of those factors are things that I think the court articulated here. I believe it took about 9 pages of transcript to explain why it reached the sentence it did. And unless this court's going to say, okay, you need to do 10 pages or 12 pages, it's going to create an artificial rule. The simple question is, did the trial court provide sufficient justification to determine whether it abused its discretion in imposing the sentence, which is the same rule we've always had, and we just want that kept in place. And we think that's sufficient to make sure the sentence is what it should be.
Okay, I appreciate your answer. Could you just touch on briefly the comment about the 17-year-old defendant certainly was of a mature age and cannot blame youth or immaturity as an excuse for this conduct, and what we're supposed to do with a statement like that?
You look at the entire course of the sentencing transcript to see if there was some aspect in which the court was improperly, or in this case, I think the court was saying this was not purely youthful immaturity. While his family being involved was a factor, he was the one who did this. The person was running away from him. This was not simply a, hey, we get together and then something unexpected happens and then this happens. Nobody else thought it was necessary to get involved in this. So for the court to say on these facts, I don't think your youthful age played a factor in this, and it was not because of the facts of the trial that he had heard and was aware of the testimony that was presented. I think that if you look at the rest of the description of the reason for his sentence, that shouldn't, it's taking it out of context to say that that in and of itself is going to be a problem.
Okay, thank you very much.
Mrs. Cavanagh?
I don't want to beat this to death, but I guess I just want to follow up. If it's, comparing the age and how the court viewed that, and I mean, that is a fact, right? I mean, it is a fact that he is under 18. He is considered youth, right? A youth. Just like the fact that his father drove him to the altercation is a fact. If that fact didn't exist, then consideration of the sort of peer pressure and all those other facts wouldn't matter. And the judge wouldn't be able to say, well, I don't think it matters that his dad drove him there, right? Like, why does he get to say, well, I don't think it matters that he was actually under 18 or a youth? Because, I mean, isn't that sort of by definition not considering the factors of youth as a mitigating factor?
I think that he does not need to consider this defendant's age at this time as a particularly mitigating factor to say it's not a mitigating factor here that results in me needing to go to a different part of the sentencing range, because you combine.
So do you think you and I apologize for interrupting you, because I want to be clear. You said that, look, you're not contending that youth shouldn't be considered, or the attributes of youth. Of course, that's part of, deciding what is and is not the characteristics of the offender. Do you believe then that the trial courts, you can consider youth, but they don't have to consider them as mitigating? They can say, well, it is either neutral or maybe it's aggravating even, I don't know, depending upon how close you are to 18 or something like that. So you can consider them, but they don't have to be mitigating.
Youth mattered in this case because otherwise Demariol Boykin would be serving life without parole. It was taken into account by the virtue of the fact that he's getting the opportunity to be released into society, whereas somebody who is 3 months older would not have that opportunity. The trial court, as Justice Kagan said, you can consider the relative age of the offender, can say, because his relative age was closer to 18 than, for instance, the 14-year-olds in Miller, that is not particularly persuasive to me as a sentencing judge for a reason to do a sentence other than 40 years because of all the other factors here.
So it's mitigating. It can just be, it's sort of a sliding scale of mitigating. It's less mitigating because he was closer to 18 or he wasn't 14 or something
As this
like
court put in Skinner, you can simply look at it sometimes and say there are no mitigating factors or aggravating factors, and therefore I'm going to impose life without parole is a permissible finding for a trial court. I think the same thing could happen here where the court could say, I don't consider your age in this case to be particularly mitigating because of the way the murder happened and all the other factors that he talked about on the record.
Could you ignore like the peer pressure issue?
The court can discuss how much it matters. And in this case, because while the father brought him there, nobody encouraged him to pull out the gun. Nobody encouraged him to shoot the victim. Sean Broyles was running away and shot in the back. So I think that the court could say, while this was a factor, it's not particularly mitigating for a term of years determination, because it means you shouldn't get life without parole, but it doesn't mean you don't deserve something at the top end of the range.
Okay. All right. Thank you.
Justice Welch.
So in this instance, the trial court, in your opinion, obviously considered youth as part of its sentencing, given the term of year sentence. Is it a problem if we find that youth was considered an aggravating factor in that determination, or is it your opinion it was definitely a mitigating factor here?
If you want to overrule Justice Kagan's footnote 8, that's what I keep coming back to, is she said, in response to the dissent in Miller, the fact that it's 17 and a half versus 14 is exactly the sort of thing that a court should consider in imposing a sentence. It's not the only factor. It's one of the factors that the court can consider. So I think that it would be an artificial construct to say that the judge needs to categorize it as mitigating or aggravating or neutral. In this case, it wasn't that much of a factor for the trial court because of the other factors that it discussed. I don't see that as an abuse of discretion. I don't think that it's certainly not clear error factually. It was in fact his age at the time. So I don't know that the bench and bar needs a whole lot of hand-holding on how to handle cases, because they handle sentences all the time with far broader ranges.
Thank you.
Justice Zahra.
No questions, thank you.
Justice Viviano.
No questions.
All right, counsel, we've used up more than your allotted time, and Mr. Karfonta, Ms. Ward, we also used up more than your allotted time. So this case will be submitted. We thank you all for your arguments.
Thank you.